very much. That was actually a very good introduction, and I'm going to be talking about a couple of the same topics. So we all know about NFIB Sebelius. We all know what this case means. I'm not going to talk about what the case means. I'm not going to talk about the opinions. I'm going to talk about the process that got us there, which I think is even more important, what actually happened. So let's go back to 2009. I'm in a room full of common law professors. If you had given in 2009 an examination said, could Congress pass a law that penalizes people for not purchasing health insurance because there's a national problem with rising premiums, and this is a way of getting premiums down according to care? If any of your students would have written no, that's unconstitutional, you would have failed them. Or you would give them a bad grade. Fast forward to March of 2012. We have oral argument at the Supreme Court, where it looks very likely that the Supreme Court and 5 justices will accept just that answer. Of course, the vote changed. Perhaps Chief Justice Roberts had a sudden sense of modesty, who knows, but the vote changed. But we do know that after arguments, it was looking pretty bad. What changed between 2009 and 2012? It wasn't the Constitution. There have been no amendments. There have been no intervening precedents that changed. The original meaning of the word regulate hasn't changed. All that stuff has remained exactly the same. What changed is how people look at the Constitution, how the Constitution is viewed. And this is a lesson we can draw with respect to popular constitutionalism. Jack Balkin and Rita Siegel and Rebecca Zietlow and lots of other people in this room and in this conference have written so much about how social movements can change the way people view the Constitution. I think this has been one of the most important and fastest changes in how the Constitution is viewed ever. And perhaps most importantly, unlike previous social movements, which have been predominantly on the left, where they've used movements to change views on abortion and same-sex marriage and equality and other issues, this has been a movement on the right, where conservatives and libertarians suddenly discovered how important social movements were to advancing constitutional law in a very short time. And with respect to your talk, most of the challenges wasn't about originalism, which I think is one of the most interesting dogs that didn't bark. But why was this challenge led by a leading originalist not framed in originalism? What does that say about the utility of that jurisprudence? Of course, the ultimate opinion had citations in dictionaries, but the movement was very simple. There's activity and inactivity. Congress has regulated your ability to do stuff before, but they can't make you do stuff. And that was the entire gravamen of the case. This wasn't Peller, where we look at the meaning of the word militia in the 18th century dictionaries. This wasn't cases like, some of the 8th Amendment stuff that look back to history. This is a very modern, contemporaneous doctrine. So I think what really sums up this case is one word which might make you a little cringe, but it's really unprecedented. This was the rallying cry of the libertarians who brought this case. Randy Barnett most prominently. That this law is unprecedented, that Congress has never gone this far before. But I think it's also unprecedented in how quickly common law changed from 2009 to 2012. The only other example I can think of is Bush v. Gore, which by necessity, in a span of about 30 days, the Equal Protection Clause suddenly assumed this new meaning of regulating state elections. That was an argument that Ted Olson and others came up with, is accepted. Likewise here, we have this argument, mandates and activity, inactivity, that was accepted. How did that happen? I think that is the enduring lesson of what happened. So in order to understand this, let's go back to 2009, 2010. What was going on in politics? President Obama had just been elected, with a huge margin. He had a mandate for change. If you look at his campaign speeches, he said over and over again, I'm going to do healthcare reform. That was his. I think there was a poll taken on the day after Inauguration Day. Healthcare was like the #2 priority. This was something very important. But what happened? There was a counter-mobilization, the Tea Party. There had been so much written about it, but this kind of movement sprung up actually right here in Chicago with Rick Santelli's speech about the Chicago Tea Party, that we need to have some sort of resurgence and return to some sort of other constitutional vision. And the Tea Party, and you can dispute their history, but they grounded their view of the law in the Constitution, with some vision of it. And this movement was used as a means to kind of oppose the president, oppose his policies, oppose tax policies, all these other things. Perhaps what gave the Tea Party the most salience was the healthcare law. If you go back to December of 2009, which is when the healthcare law was being debated in the Senate and the Congress, there was very little constitutional objection to the law. I've dug through all the legislative history. There just wasn't much discussion of the constitutionality. Chuck Grassley, a couple months before, said there's no problem with a mandate. There just wasn't an issue. All you had were a number of really academics and former Bush and Reagan lawyers writing op-eds saying that this is not constitutional, but no one really took it seriously. There were a few, but not many. What really changed was after, right as this was passed in the Senate, a number of senators realized, hey, we're going to lose this political battle. We need Plan B. And unfortunately, this was Plan B, for better or worse, the Constitution. And the Plan B was, we're going to find a constitutional argument, we're going to challenge it. The leading mover was Randy Barnett, who wrote this very influential report with Heritage, with Tal Graziano and Nathaniel Stewart, that said, hey, even within the court's own precedents, you can't do this. This is unprecedented. Now, you might agree with that argument, you might disagree with that argument, but it was a valid argument. It passed the laugh test, so to speak. And what happened over the next 2 years was, to quote Jack Balkin, taking this argument from off the wall and moving it onto the wall. And it was done so very effectively. So we have three real major movements or aspects of the movement. So there were conservative and libertarian academics who were very influential, writing blog posts, op-ed, law review articles, going on the trail, giving federal society talks, giving speeches at Tea Party rallies, advancing this view of the Constitution. It was very effective, and they were very quick in developing these ideas. I don't think this could have happened before the era of the blog. I don't think any constitutional argument could evolve which wait for law review editors to do galleys 6 months later. This was something that happened very quick. The second major player was the House and Senate Republicans. Without the backing from prominent conservative politicians, this would not have gone anywhere. I mentioned before the report from Heritage with Randy wrote on Tal Graziano. You might remember that Orrin Hatch was there. The fact that a major U.S. senator, former chair of the House of the Senate Judiciary Committee, was there, gave a lot of gravitas and lent a lot of authority to it. When Max Baucus and John Ensign and these other senators start making constitutional arguments in the Senate floor, that means something. We're not just a bunch of professors sitting in a room talking to each other. This is lovely, but this doesn't usually go anywhere. But when politicians get behind it, that gives it legs. Even look at the DOMA litigation now. When you have the House Republicans arguing in the courts versus the president stepped down, that means a lot. That's a very significant thing. Even there's some Dodd-Frank litigation going on, and a number of prominent Republicans joined that suit. I think John Boehner filed a brief. When politicos join lawsuits, they become more salient because they come into the common zeitgeist. And the third, I think, key element was the Tea Party. This was a group that kind of sprung up, really no one saw it coming. And it was almost fortuitous, a perfect storm of this constitutional movement at a time when there's about to be a constitutional challenge to this huge piece of legislation that, coincidentally, was passed by a Democrat that was very unpopular among conservatives. I was in Washington, D.C. on March 23rd, 2010. This was a day that the bill cleared the House. And I wasn't at the protest, but I was just walking around taking pictures. There were thousands of Tea Party protesters throughout the entire Capitol Mall, and they were all holding up constitutions, saying the Constitution doesn't allow this, or healthcare is not commerce, or I saw a sign that said overturn Wickard. I mean, I'm not kidding you. Reverse Wickard v. Gilbert. I mean, the fact that people are even saying these things is amazing. Like, I didn't even know what Wickard was until I was in my second year of law school. And you have protesters saying reverse Wickard, saying Article 1, Section 8. I mean, they're making these arguments. So you can disparage them and say they have a convenient view of history, and I'm not going to touch that. But the fact of the matter is there was a strong constitutional movement that evolved. And for better or worse, the opposition movement was really not very effective. Most academics, their initial reaction to the health bill was, quote Nancy Pelosi, are you serious? Are you kidding me? Balkin said there's no chance hell this is going to work. Keel Maher said there's holds no water. Chemerinsky said this is not even the slightest bit of merit. And by simply dismissing it and not taking it seriously, I think it allowed this movement to kind of work itself up. Actually, Balkin, to his credit, was one of the few people who kind of took this on head on. He had these debates with Rifkin and Casey and Mark Paul and Penn Larve. He had a number of debates. I think he was one of the few progressives who really saw the danger, and I think you can give him credit for that because of his work with social movements. He saw what was going on. And I talked to him throughout this entire debate, and it's kind of fascinating to just see how his posture evolved. I went through every blog post on Balkin through the entire 2-year period, or 3-year period, and it's amazing to just track how these arguments evolved. So you have the academics, you have the leading Republican politicos, you now have the Tea Party movement, and these are all just bubbling up, and the President Obama's unpopularity is rising. We have a presidential election coming up, and a lot of the candidates said we're going to repeal health care, especially the guy who imposed a mandate in his own state. We'll leave that to the side. But we had this evolution. And some of the key junctures when judges started saying, okay, Judge Vinson in Florida and Judge Hudson in Virginia saying this is unconstitutional. So now we have senators saying this is unconstitutional. We have congressmen saying it's unconstitutional. Now we have federal judges saying it's unconstitutional. this argument's now on the wall. It's in play. So any of your students who would have written that as an exam answer, they're not failing anymore. They're actually getting a C maybe. But to bring that C to an A, you need 5 votes, which they got. They got 5 votes, but not the right 5 votes. So the litigation strategy really was interesting for a lot of reasons, and I'm going to try and draw a few lingering lessons in my remaining few minutes. I think first we learned a lot about conservative and liberal constitutional arguments. For years, liberals have championed an activist or an engaged court. I don't like those terms, I'll use them here for simplicity. They wanted courts to be willing to be counter-majoritarian, to go against the democratic process, not being afraid to recognize new rights. This was an outgrowth of the Warren and Burger courts. And, Bill Brennan, whatever goes. I mean, this was like the liberal line judges. These are the icons. But when the Rehnquist court and then the Roberts courts are coming around, this kind of started tilting the other direction. We saw this a lot after Citizens United, where we actually had people saying we need restrained judges, we need judicial restraint, we need modesty. And I couldn't help but chuckle at how convenient that reversal is. I think it reached its apogee with NFIB. We actually had President Obama saying, I fully expect the court to uphold this law. It would be, Obama said, it would be unprecedented for the court to strike this down. And then you might remember Jerry Smith, the Fifth Circuit judge, actually asked an Obama DOJ lawyer, does your boss believe in Marbury? Does your boss believe in judicial review? And he actually demanded that the DOJ lawyer write a memo from Eric Holder that the Obama administration supports the concept of judicial review. I mean, it's astonishing. And by the way, I think that might have impacted John Roberts' thinking. I have no inside information, but you can't look at that without saying, wow, this would be really bad if I strike this down. So we have that from liberals. Conservatives aren't off the hook either. For almost 3 decades, they've been riding this. We need judicial restraint. We need restrained judges. We need judges who just are majoritarians. We don't want these anti-majoritarian judges, the Robert Bork tradition. We just don't need this. We need judges who will just simply defer to the majority. Yeah, that's out the window too. Once we have a case where we have this massive piece of federal legislation that can affect millions of people and access to their health care, and people already on this law, I mean, people had already gotten benefits, for example, pre-existing conditions, and children over a certain age can now stay in their parents' policies. There were things in motion already. This wasn't like something that only takes place in the road. And conservatives had no qualms about striking down this law. I think there was almost a slight callousness almost about how much impact this would have. Because I think they had a very clear end game of what this had to happen. And this is evidence in severability. Perhaps a more prudent approach would have just been sever the mandate, leave the rest of it, although that would have been a financial nightmare. But most of the challengers said, let's throw the entire thing out. This was Judge Vinson's position in Florida, whereas Judge Hudson would have severed it. So then that brings us to, I think, another fissure, which is conservative judges. For years, when Republicans were appointing judges, they want people who are restrained, who are activists, who would defer to majorities. I think they got just that with John Roberts. I think the Bush administration was looking for a modest, restrained judge who would not go against majorities and be very temperate of what's going on in the political climate, and they got John Roberts, and that's what he did, and that didn't work out too well. So I think we have judges in the mold of Judge Sutton, Sixth Circuit, we have Judge Kavanaugh in the D.C. Circuit, John Roberts. They're from a generation where Randy Barnett has called judicial conservatives, who are just willing to be conservative so long as it doesn't go against some moray, perhaps in the Robert Bork school of thought. But then we have, what Barnett's called these constitutional conservatives. Think of Clarence Thomas, the iconoclast, who is not afraid of striking down a law if he thinks that's what the Constitution demands. So I think we have this fissure between conservative judges, and during the next debate, you're going to see Republican pushback saying, would you have struck down the mandate? Jeff Sutton can't do that. He said he upheld it. He did gymnastics to get there. Brett Kavanaugh came up with an argument that no one else accepted. John Roberts came up with an argument that not a single academic, maybe except for 1 or 2, advanced in the entire litigation. So we're going to see a lot of that. I think also a lingering issue is for libertarians as well. But libertarians for decades have been advancing originalism as a school of thought to advance constitutional challenges. In this case, they realized early on that originalism was a non-starter. It would not go anywhere. They'd lose. So they kind of abandoned it. And I think that speaks to what's the vitality of originalism, or perhaps more pressing, if libertarians reach the same result with or without originalism, how important is the originalism? And I think that's one topic that has not been nearly addressed. And my last point, building on a wonderful point John made, is about this constitutional gestalt that Larry Salm has identified. The notion is that we have a change in our thinking, that these New Deal settlements, which we all thought were set in stone, crystallized, are no longer settled. I don't think it's safe to say that work will ever be overturned, those protesters won't be happy. But perhaps now we know that the New Deal powers will not be further expanded. They won't be contracted, they won't be expanded. And this is what the 5 votes in NFIB did. Even though I don't think there's a single holding saying that the law is unconstitutional, the way we view the Constitution has changed. And this might be the most enduring legacy with or without the Affordable Care Act. Good time? All right, thank you very much.